My lord, a group 7 hearing matter, my lord.
Give the slips. Give the slips, I shall see.
Mine is very urgent.
Group 7. Please give the slips, I am saying it. Please give the slips, I will not be able to fix any matter. Please give the slips. Give all the slips. Give all the slips.
For the inclusion of
Evaluation and just hearing there is one matter. It was taken up on the last Friday month. Since there's a possibility of time this could not be taken up yet, it has been placed under the hearing matter. So as a matter of fact, this matter is not taken up. The petitioner will be deprived of the compensation of the monthly benefits month, which is entitled.
What is the matter?
Well, the matter is with regard to the work order.
Please give the slip. It's appearing in the list already. Very well. It will be taken up in due course. I will not be able to fix matters because it's a broken bench. I sit for half of the day only on Fridays. Impossible. Please don't make impossible prayers. I don't want to say no. You want to hear no. It's not my fault.
I may permitted to mention one correction of the order relating to the circuit bench Jalpaiguri.
my urgency is on that I am.
You have given the slip, it will appear. List has been called now. List has been called, sir. I have disposed of the writ petition. I have asked you to countersign and then demand tax. Counter signature first, tax thereafter. Call karo. দুখানা আছে তো ফরজেন। হ্যাঁ। One I have said. Two I have dismissed the writ petition. I'm sorry. I have considered the judgments because there are 3 violations successive. I have seen that the fines that were imposed were also not paid instantaneously. Fines were imposed. Fines were paid after the first round of litigation before this court. So this effort of whitewashing conduct later will not.
But my lord, the amount is suspicious.
Can't be helped.
That will be there.
Item number 3, Lordship, I am appearing on behalf of the Union of India.
The department. The
matter has been placed under to be mentioned, Lordship, for correction, though we do not have any intimation regarding the same.
Very well. This matter has been listed at the instance of the department. Full stop. It appears that the writ petition number has been incorrectly mentioned as WPA 3156 of 2019 instead of WPA 3165 of 2019 in the order dated May 21, 2025. Full stop. The writ petition number may accordingly be corrected by deleting WPA 3156 of 2019 and inserting WPA 3165 of 2019 in the order dated May 21, 2025. Full stop. The other portion of the order shall remain unchanged.
Oblige, Your Lordship.
Lordship, I am for the petition, I am not sure. This is a 2024 writ petition, Lordship. In this, I had challenged the West
It's
Bengal
appearing for correction.
for correction.
देखिए
My
देखिए
can is listed today.
लिखो. This matter has been listed at the instance of the department.
I appear for the union.
Full stop. It appears that by an order dated January 28, 2025, it had been directed that the petitioner's name in the cause title of the writ petition be amended. And recorded that the petitioner had gone it appears that by an order dated January 28, 2025, it was recorded that the petitioner had undergone a change of its name, full stop. The petitioner's present name is Elever Digital Infrastructure Private Limited. Full stop. The cause title of the writ petition was directed to be amended accordingly. However, the cause title of the writ petition in the order dated June 17, 2025, where the unamended name of the petitioner, full stop. The cause title of the writ petition in the said order dated June 17, 2025, be therefore amended by deleting the name, এই নামটা delete করবেন etc, and incorporating the name ওই পরের নামটা in place and stead thereof. The other portion of the order shall remain unchanged. ঠিক আছে? Next.
My lord, before that, my lord, kindly take up item 6, contempt matter.
No.
It will
This
take
matter-
1 minute time, my lord.
No, let me finish this matter.
1 minute time it will take.
Well, I am appearing for the contempt, my lord. Order has been complied with.
What order is it
No, my lord,
complied with?
Order has been
only,
complied with.
only,
Then it won't take 1 minute.
my lord, but
Let me
only,
finish.
only specific date is to be given, my lord. My lord, they have written.
Sir, it won't take 1 minute. Please wait.
My lord, only, kindly go
They
to
have
the,
given you a hearing or not?
yes.
But
Yes, an order has been passed. This order has been passed.
I
My
will not
lord,
be able to revisit my order.
my lord, only prayer is,
He agreed to
kindly
challenge the
specify the
order.
date. Only, nothing more.
They
Nothing
have
more.
given you a hearing, Mr.
A hearing
Samat. That
and
was all that
passed
the
is in
order said.
My
order.
lord, what they have
In
said,
favor,
that the
in
application
I
his
cannot
favor.
go behind the order in contempt.
My
Mr.
lord,
Samanta, I am in
but-
contempt
my lord,
jurisdiction.
kindly give me 1 minute, that the application for the renewal of permit shall be considered and the above mentioned permit will be renewed. Well, that's enough.
Yes,
You
renewed.
file a fresh writ if you are with. That is not a cause
My
for
lord, my lord, my lord.
Call the next matter, please. Call করুন. Continuing matter to call করুন. আবার call করুন.
My lord, this matter, my lord, item number 6 is, my lord, disposed of.
No order has been passed as yet. I'll have to hear it.
My lord, my lord.
Lord, I appear on behalf of the respondent,
hear
led by
it.
Mr. Saha. But I'm led by Mr. Saha, he is on his way.
দেখি বাকিগুলো দিন, একটা দিয়ে হবে না।
My lord, My lord, I had, my lord, on the last occasion, my lord, started, my lord, placing, my lord, the order of the High Court,
Can
my lord, of 10th of April, 2025. That was, my lord, the writ petition challenging, my lord, the first order passed on review.
can দিচ্ছেন কেন? আপনারা এতদিন ধরে আছেন, ফাইল বোঝেন না।
My lord, kindly take volume 4, my lord.
এগুলো রাখুন।
Matter is good for that day, but this is the other matter. Okay.
রিলিজ করে দিন, আদার ম্যাটার্স রিলিজ, আদার ম্যাটার্স রিলিজ করে দিন, বলে দিন।
My lord, this is where I had ended, my lord, on the last occasion, 10th of April 2025 order, which is in volume 4, my lord, page 684. My lord, my lord, just come to the relevant portions. My lord, just to recap, my lord, para 32 at page, my lord, 693 is where the findings start. And your lordships would recall, my lord, that our submissions, my lord, are, my lord, all recorded, my lord, prior to this in the order. Then kindly come to, my lord, paragraph 37 at page 694.
Yes.
The ground for which the petitioner has been banned submitting false declaration certificate carries a, kindly mark the words, my lord, maximum ban period of 2 years. The period of ban is to be decided based on the gravity of the offense and the quantum of loss suffered by CIL. Petitioner alleges that the principle of proportionality while imposing punishment has been ignored. Admittedly, in the instant case, Chairman CIL in the impugned order has mentioned about the reasons for banning the petitioner, but has not given any reason as to why the ban is to be imposed for the maximum period. The impugned order also does not mention as to whether CIL or any of its subsidiaries suffered any loss on account of submission of false declaration certificate by the petitioner. The authority may not accept the explanation or the interpretation given by the petitioner as regards the certificate relied upon by it, but the authority would be required to give reasons as to why the maximum period of ban is to be imposed. The very fact that the tender document prescribes only the outer limit of the ban period, but does not stipulate a fixed time period for the ban to be applicable, implies that there is scope for banning an offender for a period less than the prescribed outer limit. Had the tender document specified that for the subject offense, the ban shall be applicable for a period of 2 years, then there would not have been any scope for reduction of the ban period. However, since the tender document prescribes that the ban period shall not exceed 2 years, the same gives an indication that in a given case, the ban period may be less than 2 years. It is not mandatory that in each and every case where an offense is detected, the offender has to be mandatorily banned for the maximum period of punishment. This is the finding, my lord, of the learned single judge. The chairman appears to have missed out this aspect of the period of ban. The period of ban is to be decided on 2 factors. Kindly see, first, the gravity of the offense, and second, the quantum of loss suffered by CIL or the subsidiary companies. In the impugned order, there is no reflection as to whether the period of ban has been decided keeping in mind the aforesaid 2 factors. So, my lord, when maximum penalty has been imposed, my lord, first, my lord, the law is settled. A reason has to be given, my lord, why maximum penalty. My lord, here, my lord, the purchase conditions, my lord, the tender conditions which provide for, my lord, banning, say, my lord, that, my lord, when imposing an order of ban, 2 factors have to be considered. My lord, one is gravity, and the second, my lord, is loss, my lord, caused to the procuring entity. Both have to be there. As the court in the earlier writ petition filed by the petitioner did not interfere with the order of ban and the only issue which was directed to be considered is the review modification of the order of ban. The impugned order, kindly note this, appears to be reiteration of the ban order. The chairman CIL appears to have misdirected himself and failed to appreciate the order of the court in its proper perspective. The chairman was not required to substantiate or fortify the reasons for the ban, but was to, now kindly mark this, my lord, was required to consider the request of the petitioner seeking review of the ban. The impugned order is absolutely silent on it.
Period.
Yes, my lord, not just period, my lord, we had made a representation. My lord, why, my lord, the ban, my lord, should not, my lord, continue for 2 years. My lord, that had not been considered, my lord, in the first review order. And I'll show, my lord, that has also not been considered in the second.
Mr. Mukherjee, your case is that there should be no ban at all? Or
My
the
lord, that
ban
is,
should have
my
been
lord,
less?
that is my first case. But my lord, today, my lord, before your lordships, my lord, I have to, my lord, in any event, my lord, having pushed your lordships, my lord, to take up this matter, at least, my lord, say, my lord, that the review should have been considered, and at least, my lord, the ban could not have been 2 years. And I have already brought it, my lord, to the knowledge, my lord, of, my lord, the banning authority and, my lord, the reviewing authority, my lord, what were, my lord, the elevating circumstances, and by reason of the ban, over at least a period of 1 year out of the 2 years, the losses that I have suffered. I had done that. Now, my lord, the impugned ban is absolutely silent on it. In isolators, the Honorable Court was of the view that the debarment order had been issued without due regard to the undeniable factual situation. Now kindly see, in the case at hand, there is nothing on record to suggest that the reasons mentioned by the petitioners for reduction of the period of debarment was at all considered. The authority ought to consider the factors on which the maximum penalty can be imposed. Then, my lord, in Kulja, the court held that a decision to blacklist a contractor may be open to judicial scrutiny on the doctrine of proportionality. The penalty imposed ought to be proportionate to the gravity of the offense. Here, the issue of proportionality does not appear to have been considered at all. In view of the above, the court is of the considered opinion that the impugned order does not address the issue of reduction of the period of ban as prayed for by the petitioner. The impugned order is liable to be set aside and is accordingly set aside. The chairman CIL is directed to reconsider the prayer of the petitioner. Kindly note, afresh only on the point of proportionality. So, my lord, I am, my lord, restricted by this order itself. Only on the point of proportionality of the order of ban imposed, a reasoned order shall be passed addressing the fact as to why ban for maximum period is to be imposed upon the petitioner. The reasoned order shall also disclose the gravity of the offense and as to whether any loss was suffered by CIL or any of its subsidiaries because of the local content certificate submitted by the petitioner. So, my lord, it's a loss, my lord, to the procuring entities and, my lord, the gravity of the offense.
This becomes axiomatic because it is only on the basis of the satisfaction of these twin conditions that
Correct.
the ban can reach the ceiling limit. There is a
Yes, my
ceiling
lord. So, my lord, if loss is 5 rupees, gravity, my lord, is, my lord, it cannot, my lord, be, my lord. That's, my lord. Now, my lord, kindly come to. So, my lord, after this, my lord, we go, my lord, to, my lord, for the second, my lord, adjudication by, my lord, the chairman. Now, my lord, that's the order of 2nd of May, my lord, which is at page, which is volume 4, my lord, page 718. My lord, kindly see, my lord, kindly ignore the first paragraph. My lord, that, my lord, paraphrases the order. Then, my lord, second, the decision for imposing the 2-year ban on you was accordingly taken up for reconsideration. In revisiting the issue of the 2-year ban, following factors are considered. Kindly see the factors which are considered. My lord, the tender number for, my lord, bulk. Then, my lord, what is the tender condition with regard to local suppliers? The effect of being class 1 local supplier, and then, my lord, terms and conditions, methodology of purchase preference. My lord, these are all part of, my lord, the tender conditions. Then, my lord, kindly come to, my lord, page 719, bottom. My lord, last 5 lines. There was a provision in the NIT that false declarations will attract banning of business for a period up to 2 years, along with such other actions as may be permissible. As per PPP, Made in India policy false declaration will be in breach of the integrity of Rule 175, 1, subclause I, subclause H of the General Financial Rules, for which a supplier or its successors can be debarred for up to 2 years as per Rule 151.3 of General Financial Rules so and so. Rule 1 says that a may debar a supply for any of its successors from participating in any procurement process undertaken by it for a period not exceeding 2 years if it determines. Moreover, CIL purchase manual, etc. Now, my lord, important thing is, my lord, now they rely on the general financial rules, which was not part of the show cause notice. But, my lord, I don't have a problem. They have relied on it. It helps me. I want to, my lord, show it to your lordships. My lord, I have, my lord, the relevant extract. Copy of this. Now, my lord, yes, my lord, kindly have a look at Rule 175.1, my lord. That's, I think, the penultimate page of what I've handed up. Or, my lord, one page, my lord, prior to that. Rule 171.
Code of integrity.
Code of integrity. Now, my lord, kindly see, no official of a procuring entity or a bidder shall act in contravention of the codes, which includes. Now, my lord, kindly turn over the page. Kindly come to clause H. And that is, my lord, what has been referred to at page 719, last line. Making false declaration or providing false information for participation in a tender process or to secure a contract. My lord, this is what it is. Now, my lord, kindly have a look at, my lord, 151, my lord. Rule 151, which is, my lord, third page of the document I've handed up.
Debarment.
Correct. A bidder shall be debarred if he has been convicted of an offense. My lord, that's PC Act, Indian Penal Code, or any other law. Then, my lord, 2 says a bidder debarred under subsection 1 or any successor of the bidder shall not be eligible to participate in a for any procuring entity. Kindly mark this. For a period not exceeding 3 years, commencing from date of debarment, Department of Expenditure will. So, my lord, this is PAN, my lord, government undertakings, my lord, that if there's, my lord, Prevention of Corruption Act, my lord, or my lord, any other, my lord, offense, my lord, under any law, my lord, it's 3 years, but it's up to again. And, my lord, this for any procuring entity. Now, kindly have a look at 3. A procuring entity may debar a bidder or any of its successors. My lord, I don't come under 1 and 2. My lord, I come under 3. And that's what they refer to, my lord, in there, page 720, my lord. A procuring entity may debar a bidder or any of its successors from participating in any, kindly note, procurement process undertaken by it for a period not exceeding 2 years. So again, my lord, not exceeding 2 years. If it determined that the bidder has breached the code of integrity, the ministry department will maintain such list, which will also be displayed on the website. And then, my lord, opportunity of hearing, my lord, to the bidder, my lord, is provided. So, my lord, here also, my lord, is the maximum. It's not correct. My lord, it's not automatic that, my lord, if I fall under this breach of code of integrity, that it will be, my lord, 2 years and nothing needs to be looked into. And, my lord, the instruction to tenderers and, my lord, procurement rules, my lord, as far as, my lord, Coal India and its subsidiaries are concerned, my lord, it specifically provides that, my lord, the blacklisting, my lord, is maximum 2 years, and the factors which are relevant, my lord, in, my lord, determining the extent of blacklisting are, my lord, gravity as well as, my lord, my lord, loss caused to the procuring entity, not loss to anybody else, loss to the procuring entity. Now, my lord, kindly come to, my lord, then there's a reference to the purchase manual, etc., etc. Then, my lord, kindly take, my lord, the show cause notice. My lord, is referred to 721, and then, my lord, the findings start, my lord, at page 721. My lord,
So this is
paragraph 1.
finding as regards the gravity.
Gravity. So, my lord, what is being considered, my lord, is gravity. The offense committed by you is grave in view of the following facts. So, my lord, in the above mentioned tender with respect to bulk explosives, my lord, this is 2023, your lordship would recall, the bids were required to be submitted by you against requirement of CIL subsidiaries. My lord, there are, my lord, 7 subsidiaries mentioned here. You had offered against the requirement of ECL, BCCL, CCL, so and so, out of the 7, 6. As per tender document, the order in which distribution of quantity is to be made as follows: 4 parallel running contracts. RCs are running contracts, are to be concluded in the predefined ratio 40, 30, 20, 10. Then, my lord, first preference is given to class 1. That's the procedure. Now, my lord, they come to the running contract, my lord, which we had, my lord, participated in. That's, my lord, to supply to 6 of these. With respect to running contract number 20, your position in various CIL subsidiaries was as follows. Against requirement of ECL, in the tender, you were L3. There were 5 qualified class 1 suppliers other than you. By falsely claiming, my lord, they are giving, my lord, the consequence. Falsely claiming to be class 1 local supplier, you circumvented the eligibility condition of the tender, which resulted in placement of 20% share of so and so on you. So, my lord, I come second last because I was L3, and, my lord, I get, my lord, 20% of the contracted value. The effect of that, my lord, is the estimated value of this order is approximately 44.15 crores. The price of rupees so and so. The said order for 20% should have been placed on any other class 1 local supplier instead of you, had you rightly indicated that it was a class 2 local supplier. So, my lord, it's a deprivation, according to them, of, my lord, other, my lord, class 1. But kindly note, not one complaint, my lord, has been, my lord, placed, my lord, in this regard by, my lord, any other, my lord, local class 1 local supplier. Then, my lord, similarly, my lord, B is again falsely claiming 30% share you got with regard to CCL. Estimated value is 97.16 crores. Said order should have been placed on other class 1 local suppliers instead of you, had you rightly indicated that it was. Then, my lord, here again, no complaint. Similarly, my lord, apropos, my lord, Southeastern Coalfields Limited, my lord, it's again, my lord, the same. And where, my lord, I was L5. There were 4 qualified class 1 local suppliers other than you. So, my lord, it's not deprivation of anyone. Everybody got. But, my lord, if I were out, they would get, my lord, more. Here they got 35, 25, 20, 10, 10. My lord, I got only 10. They would have got, my lord, it would have been 40, 30, 20, 10. Nobody is being deprived. It's just the quantum. So, my lord, who was 10 with me, there were 2 10s. He would remain at 10. And, my lord, others, my lord, who was 20 would have remained on 20. But, my lord, it would have been 40, 30, 20, 10. Rather than 35, 20, 20, 10. My lord, that's apparent from the distribution, my lord. I don't think there's a problem regarding this. From the above, it is clear that you have made offer and secured order worth over 230 crores, which should have been placed on other eligible class 1 local suppliers instead of you, had you correctly represented yourself itself as a class 2 local supplier. Then, my lord, it is established from the records and circumstances that you willfully adopted a deceptive, this is, my lord, addition. Now, my lord, is justifying the ban, not, my lord, and, my lord, this is, my lord, really, my lord, quoting. They were required to examine, my lord, my request for, my lord, proportionality. None of this is considering, my lord, gravity ends here. Then, my lord, paragraph, my lord, the next paragraph is, it is established from the records and circumstances that you willfully adopted a deceptive and unfair method to gain advantage over other participants in a public procurement tender by circumventing the public procurement preference so and so. This act involving the submission of false information enabled to secure a contract in a market characterized by limited competition, thereby distorting the level playing field intended under the policy. Such conduct has far-reaching legal and constitutional implications. Then, my lord, is, my lord, the response of the chairman on with, my lord, the aid of Article 14, my lord, of the Constitution. My lord, saying, my lord, that the very fact that, my lord, I deprived, my lord, local, my lord, suppliers of, my lord, grade 1, class 1, my lord, my lord, did not, I prevented, my lord, my lord, procuring entity from having a level playing field. And, my lord, treated, my lord, by virtue of which they could not treat equals as equals. That is, my lord, what they are saying. And then, my lord, your lordship will find 723, my lord, second paragraph. Misleading CIL on the basis of fraudulent misrepresentations has exposed CIL to various potential litigation, including by other bidders who can claim deliberate wrongdoing by CIL and resulting in loss to them upon being deprived of orders which they would have been entitled to get had you not fraudulently represented yourself to be a class 1 local supplier when it is not so in reality. So, my lord, I pause here. My lord, there are two things coming in here. One, my lord, a discussion of gravity of the offense. So, my lord, by, my lord, making, my lord, I'll assume, my lord, wrong information, false information, whatever. My lord, I kept, my lord, others out from, my lord, the competition, where, my lord, they were entitled, they were qualified, my lord, to get the bid. But the fact of the matter is, my lord, as on date, my lord, there is, my lord, no complaint by any of them, no, my lord, litigation. There's a potential. And, my lord, this was a contract given in 23, which is, my lord, it's run its course. There has been, my lord, no litigation, my lord, here. Apropos, my lord, these contracts. Then, my lord, kindly come to, my lord, paragraph 3. This is now, my lord, Article 19(1)(g). My lord, that, my lord, government entity, my lord, was prevented from, my lord, participating in, my lord, business relationship with, my lord, others, my lord, who, my lord, could have qualified. My lord, we don't have any, my lord, details other than this, but, my lord, I'll say, my lord, it's again justifying the ban, but, my lord, not the gravity, my lord, of, my lord, the offense, or, my lord, my lord, why the period had to be, my lord, maximum. These are, my lord, adding reasons, my lord, which justifying the ban. Till now, your lordship will find that, my lord, what I had stated in my 2 letters, my lord, have not been considered. My lord, I'll come back, my lord, to the letters. In the case of procurement, now, my lord, so, my lord, I will, my lord, give them, my lord, the benefit, my lord, that, my lord, they have considered gravity. I cannot say, my lord, that they have not considered gravity. They've considered gravity. My lord, gravity for all, my lord, would be the same. Question is, my lord, did gravity lead to, my lord, a loss? And, my lord, the extent of the loss. Because, my lord, anyone who falls under this has to be treated, my lord, as the same breach of code of integrity. So, my lord, the gravity here is that I deprived some others, my lord, to, my lord, contract. Now, my lord, in the case of procurement of explosive by CIL for its subsidiaries, it is to be noted that running contracts with various suppliers are generally valid for 2 years and tenders are floated biennially. Thus, if an entity person is blacklisted for a short term, then such entity person may not even suffer any tangible consequence of the blacklisting, as by the time of the next tendering process, such entity person would be eligible to participate in the tender, thereby frustrating the very object and purpose for which the ban is sought to be imposed. Hence, the ban of period of 2 years. So, my lord, running contracts are given every 2 years. My lord, and my lord, there can be additions, my lord, to it during the period of 2 years. So, unless the ban is 2 years, my lord, no purpose will be served. But that is not, my lord, the law. My lord, the banning, my lord, is, my lord, it's state largesse involved. Banning cannot lead to, my lord, stoppage of business. Now, my lord, kindly see, such imposition of ban of 2 years is as such considered reasonable and proportionate to the offense of subverting the public procurement system, which is a domain critical to public interest and national policy objectives. Allowing a supplier to escape liability despite having furnished false and misleading information will not only defeat the statutory objectives of so-and-so policy, but will also amount to institutional endorsement of such fraudulent misrepresentation. thereby compromising the credibility and sanctity of the public procurement framework. Though the specific quantum of now kindly note this, fellow, this is very important. Though the specific quantum of financial loss arising from misrepresentation cannot be ascertained precisely, the nature and gravity of the offense in this case is such that it is the heart of public trust in government, considering the object to be achieved in the instant case, where tender is floated on a biennial interval so as to act as a meaningful deterrent, which is required to uphold the integrity of government procurement. Clause so and so is required to be interpreted in the manner that the period of banning has to be determined on the basis of gravity of offense and or the quantum of loss suffered. Now I pause here. This is contrary to the order of court, which has already, my lord. And my lord, the reason they cannot quantify the loss is, my lord, the sale, my lord, is at L1 price. My lord, the rank, my lord, is determined. If I'm L5, I will be offered, my lord, the right to a smaller quantity, but by matching the L1 price.
So there is no loss.
No loss, cannot be, my lord. Then, my lord, it is also not out of place to mention in this regard. And, my lord, the second thing I say is the interpretation given here, my lord, is contrary to the order of the court, number one, contrary to their own bid documents, contrary, my lord, to, my lord, the financial rules which they themselves, my lord, rely on. Because maximum there has to be a reason. And the reason, my lord, is specified in their purchase manual and in the tender document, both. Then, my lord, kindly see, it is not out of place to mention in this regard that clause so and so of the purchase manual provides that considering the gravity of such misconduct where warranted, existing ongoing contracts may be terminated along with banning as per provision of clause. Now, my lord, kindly, my lord, this is very, very important. Just take out 6.13.5.6 of the purchase manual. My lord, I'm just reading it again. I'll take it out and show it. It is also not out of place to mention in this regard that clause so and so of the purchase manual provides that considering the gravity of such misconduct, where warranted, existing ongoing contracts may also be terminated along with banning as per provision of the clause. Because, my lord, one of the arguments was, my lord, they didn't even, my lord, find, my lord, the gravity was such as to warrant cancellation of running contracts. Right from day one, my lord, that has been our case. That if it was so bad, this misrepresentation, my lord, they should have, my lord, cancelled my running contracts as well. They are also saying so. But now they give an excuse. Now, my lord, kindly have a look at, my lord, clause, my lord, 6.13.5.6, which is, my lord, at page 494. Volume 3, my lord.
Yes.
My lord, kindly have a look. Clause 6.13.5.6. My lord, 494 bottom, my lord.
Yes.
Yes. During the period of banning, no business dealing can be entered into with the firm by the subsidiary company which has issued the banning order. In case banning order is issued by Coal India Limited, it will be applicable for the whole of Coal India. Now kindly see the next. Normally, contracts conclude before the issue of the banning order shall not be affected by the banning order. Then, my lord, however, considering the gravity of the offense, the existing ongoing contracts may also be terminated after observing the formalities of termination as stipulated in the order in the existing contract. The order of banning should specify whether all the existing ongoing contracts are covered under the banning or whether certain existing are excluded. So, my lord, if the gravity, my lord, equals to, let us assume, my lord, loss is also achieved, but, my lord, gravity, my lord, was such that, my lord, maximum penalty could be imposed, then, my lord, running contracts should have also been terminated.
Which has not been
done. Admitted. Now what do? My lord, they now justify that. Kindly see, in the instant case, the running contracts have not been have not been terminated, and as such, kindly give me a moment. And as such, decision is also to be viewed as providing some leeway to ideal by not imposing the strictest of punishment. So, my lord, if gravity, my lord, was so bad, my lord, how is this, my lord? And that is only for gravity. The rule says, if the gravity is such, and which should be, my lord, commensurate with maximum punishment, my lord, running contract should have gone. You can't say, no, I've given him some leeway by this. Then a gravity is not that much. It cannot be, my lord, maximum punishment. Now, my lord, kindly see. Thus, to conclude, the earlier decision to impose a 2-year ban is just, legal and proportionate. Accordingly, with respect to the period of ban, the same is retained to be for 2 years, since in the given facts and circumstances, the same is proportionate. Kindly note again, to the gravity of offense committed, particularly considering the object sought to be achieved by even imposing a banning order. The ban of 2 years in this particular case is in accordance with principles of natural justice and mandate, and is required to protect the integrity through this reasoned order. So, my lord, in short, my lord, first, my lord, the second, my lord, review order, my lord, is really in violation, my lord, of the earlier, my lord, order of the learned single judge when disposing of, my lord, the writ petition against the first review order. When it set aside, my lord, that review order, my lord, the court order said 2 factors have to be considered, that is gravity and loss, and on that basis the law of proportionality has to be applied. Here, my lord, loss has been ignored, my lord, totally. And second, my lord, an interpretation has been given which is contrary to the interpretation given by, my lord, the High Court in the earlier round of litigation, pursuant to which, my lord, the second hearing is given. Now, my lord, now, my lord, the second, my lord, issue, yes, now, my lord, the second, my lord, which is, my lord, second issue, my lord, which is important is, my lord, even the gravity according to them, because now they are relying on this clause of the purchase manual, was, my lord, not, my lord, that would be commensurate with maximum penalty. Because they permitted the running contracts to continue. They didn't cancel those. Third, my lord, there were 2 letters of ours my lord, which are, my lord, 1 minute, I have. Where are the letters? Yeah. My lord, kindly take, my lord, page 504, my lord, 18 July 2024 letter. My lord, that's volume 3, my lord.
Yes.
My lord, this was a letter seeking review. Now, my lord, kindly come to 505.
Yes.
My lord, last paragraph. You will recall that in late 2021, the economy was still recovering from the after effects of COVID. The extraordinary series of events that took place from the beginning of the order period affecting ammonium nitrate supply needs to be taken into account for any final decision. Some of these are mentioned. My lord, right up to, and these are, my lord, all, my lord, admitted facts which have been noted, my lord, by the central government and Coal India, that, my lord, relief, my lord, should be granted, my lord, to, my lord, manufacturers of explosives who require ammonium nitrate because of 3 reasons. My lord, prices, my lord, were low, high. My lord, ammonium nitrate is required for explosives. My lord, the prices of ammonium nitrate, my lord, were at abnormal levels, both domestically and, my lord, in, my lord, the international market. Number one. My lord. Number two, my lord, because of the Ukraine war, my lord, there was, my lord, a shortage of ammonium nitrate, my lord, in, my lord, the international market. Third, my lord, even in the Indian market, my lord, there was, my lord, a shortage. So, my lord, a representation had been made to the central government, which was supported by the procuring entities for, my lord, reliefs to be granted. We have, my lord, listed those. My lord, there, my lord, because our, my lord, certificate was based on estimates, and, my lord, we had used, my lord, a wrong calculation for one of them as to, my lord, the calculating the import content. My lord, it's not that, my lord, local content, my lord, was 3%, and, my lord, the imported foreign content, my lord, was 97%. My lord, they all, I'll show the figures. My lord, it was, my lord, in, my lord, substantial, my lord, compliance. My lord, I'll show the, take out the figures, that 50.
Then what riled them?
I don't know, my lord. They said they got a letter. The ministry of, my lord, the minister got a letter and pointed this. Whatever it is, my lord, they banned me, my lord. But I cannot look backwards now at what has already happened. I'm on the future. I'm on the future. But, my lord, the admitted fact is, my lord, 20th April, my lord, order, my lord, said, my lord, these have to be considered. The order is completely silent on, my lord, these facts, my lord, which were beyond our control. Yet, my lord, it was supplied, my lord, at this price. The same price. There was no, my lord, default, my lord, in complying with the running contract. Price was maintained, supplies were maintained. Now, my lord, the second, my lord, is another letter. My lord, and, my lord, I have been, my lord, a supplier for how many decades? You don't have to look for that. Yeah, you should know it. You're living this file. Come on, tell me. Yes. My lord, we've been supplying, my lord, for 4 decades. My lord, I remember it was in the 40s. It's happened. This is the first time, my lord, that this has happened. For 4 decades, my lord, and is not disputed. Now, my lord, comes, my lord, the next letter of 24 December 2024. My lord, page 526. My lord, an associate company of Coal India, my lord, Singareni Coal, my lord.
Yes.
My lord, which is in, I think, the state of Telangana. Am I right? My lord, they, my lord. My lord, also, my lord, it's at 526. My lord, that's volume.
Yes, got it.
Volume? Okay. Volume 3, my lord, also at work.
Yes.
My lord, now kindly note, my lord, the last 2 paragraphs. Recently, Singareni Collieries disqualified us and did not consider our bid solely because of the ban imposed by Coal India. We had to close our operations at our Gundam unit at Telangana state and retrench manpower. This resulted in loss of our business of 200 crores for a period of 2 years. Imposition of the ban halted our supply chain, resulting in closure of manufacturing activities. This has not only affected the company's financial stability, but also affected livelihood of 70. In addition, our company is not able to submit bid against any tenders being floated by any PSU and or government departments, since all PSU government tenders require no banning certificate from our company as one of the preconditions. My lord, any state undertaking, my lord, if it's banned, has a banning order, though it says you won't deal with us, my lord, declarations are required in all state, my lord, tenders, my lord, that you have to disclose a banning order. So we have to disclose this. It's not just 2 years for them. My lord, it operates across the field. That's what we are pointing out. We would like to inform you that we are the preferred proven supplier to the following products for open cast so-and-so. You will recall the incident when Bharti Colliery BCCL accident took place in which more than 50 miners, we were the only supplier who saved BCC by supplying a permitted explosive to maintain uninterrupted. We once again request you to consider a review letter sympathetically in reference to 2 above and immediately lift the ban. And my lord, this letter, my lord, is of 24th December 20. Here again, when no action was taken, is when we moved and had our first order, my lord, of 20th of January, which my lord required, court didn't go into the merits, said consider the review. Then came the first review without addressing proportionality. Now, my lord, it was sent back. Say you keep these in mind and do it. My lord, this is, my lord, the result. Now, my lord, one other important fact, my lord, I need to, my lord. Now, my lord, I want to, my lord, and my lord, written submissions were also given on this. I can give your lordship the page number. My lord, page 533 of this very volume. The same facts which were now the ban is, my lord, over 1 year. My lord, when this letter was written, my lord, it was about 8 months. Page 538 we mentioned.
Yes.
My lord, that we have, my lord, suffered. It's not, my lord, that we have, my lord, not suffered at all. Now, my lord, kindly, my lord, 2 factors, my lord, I wish to draw your lordship's attention to. One, my lord, even with regard to gravity of the offence, one, my lord, relevant aspect has not been considered at all. That, my lord, there can be, my lord, a basis, my lord, of, my lord, giving a certificate on, my lord, estimates. And, my lord, if estimates are not met later, which I shall show your lordship how close we were, my lord, then, my lord, it has to be borne in mind that it was not on the basis I concealed actual figures. I actually gave estimates. Because it's a future supply. My lord, it will have this content. So, my lord, kindly, my lord, take, my lord, the, my lord, guidance note, my lord, at page 458. You haven't done it here, no? That's what I wanted you to do. Yes.
Guidance note is at
My lord, it starts at page 450, volume 3, my lord, at 458. And then give the content.
Yes.
My lord, kindly see, my lord, the notes. My lord, in the case of tenders, the manufacturer suppliers may calculate the local content percentage based on best drawn estimates of domestic and imported so and so for goods, services, and overheads. These estimates should be supported with relevant
Page 458.
458 clause 3.
Clause 3, yes. In case of tender.
Yes, my lord, this was for, my lord, the future. My lord, kindly now take, my lord, 444, my lord. Page 444.
Yes.
Volume 3 only, my lord.
Yes.
My lord, this gives, my lord, percentage of local content. My lord, July 21, period considered by cost auditor for certificate submitted based on average of all location. Then, my lord, percentage of local content.
Yes.
Now, my lord, considering transportation cost of imported material from port to the factory as part of cost of domestic material, my lord, it's 32.03% was achieved. Then with transportation cost considered as cost of imported material, 25.89%. Right hand side, my lord, according to me, is the correct way of, because of the amendment, my lord, to the purchase policy. should, my lord, is the correct way of computing. Because if I import and I transport from the port to, my lord, my factory, that is not local content. That will be treated as import content. There was a clarification. So I accept the right hand figures. Now, my lord, kindly see October 21 to March 22. 68.7%, my lord. Kindly go by the right hand. 66.30%. Lordship has that?
Yes.
Here, my lord, I am above. Then, my lord, kindly see financial year if it's taken 21 to 22, I'm 45.30%. 22 to 23, my lord, 43.89%. April 23 to September 23, 47.70%. Average of RC period, October 21 to September 23, 47.50. Average of period 21 to September 23, 45.1. My lord, I am 5% short, which I failed to achieve, my lord, on, my lord, the basis of estimates. Is it so grave, my lord? I'm also on, this is on gravity. And the RC, my lord, here it started in October 21, which is why that's the starting point.
And where is the imputation that they have done, saying that you have shot over by
Yes,
by
my
what
lord.
percentage?
My lord, that is, my lord, this is that order, my lord.
Acha.
This is the show cause. And my lord, after the show cause, my lord, the order, my lord, if your lordship takes the order, my lord, I believe, my lord, it's at 463 of volume 3, my lord. Now, my lord, kindly come straight away to 464.
464.
Yes, my lord. Subsequently, your reply with a letter, my lord, the middle paragraph.
Yes.
Subsequently, your reply with a letter dated so and so has been examined, and it has been found that charges of willful suppression, furnishing stand against you. Consequent, the following decision. So they go by what's in the show cause. They don't give anything else.
So this content was tested after
My lord, my lord, what happened was after the complaint, my lord, on which they acted, my lord, they appointed an independent auditor, my lord, who, my lord, consulted us. But my lord, I must tell your lordships one thing. Though we asked for that report, we never got it. We never got it. And on that basis, my lord, the show cause was issued. Even when, my lord, we went in for the review, we asked for that report, but we didn't get it. It's recorded in the letters. But all that, my lord, is spilt milk today, my lord. I have already suffered the ban, my lord, of
more than 1 year.
More than 1 year. I've already suffered. Now the question is, my lord, if this is the case, my lord, I first say, even on gravity, my lord, they have not satisfied for maximum, my lord, on their own showing, because the running contracts have continued. And secondly, my lord, if your lordship sees the table on which the show cause notice is based, and my lord, on that basis, they have come to the conclusion that I have not supplied 50% or more local content. My lord, then, my lord, in my respectful submission, my lord, it's not, my lord, something that I've entirely, my lord, imported. So substantial, my lord, local content. And my lord, if anybody has been deprived, third thing, my lord, it would be other, my lord, grade 1 local suppliers, class 1 local suppliers, none of whom, my lord, have, my lord, raised a grievance as of date. And my lord, second point is, as far as, my lord, loss is concerned, my lord, there could not have been, and nor have they, my lord, indicated, my lord, any loss. Third, violation of order of court, my lord, and my lord, what I had submitted for my lord proportionality test, my lord, has not been considered, including the loss, my lord, that I have suffered. In fact, my lord, there are two kinds of tenders. My lord, one is bulk, one is cartridge. My lord, cartridge, my lord, the day I moved this writ petition, my lord, technical, my lord, evaluation had been done and tender proceeded with. The learned judge, my lord, said, this, you can't participate here. I've gone up on appeal, that appeal is pending. This was, my lord, the second, my lord. When bulk came out, my lord, then I moved again, saying, now this has come out, you please allow me to participate. And that's the interim order, which I showed your lordship. And my lord, we were given liberty to mention elsewhere, my lord, for my lord hearing. And 13th August is, my lord, the last date, my lord, for submitting, my lord, tenders. Now, my lord, on, my lord, banning orders, my lord, there are two cases, my lord, which I wish to cite. Give Kulja first. Is Kulja here? Okay, tell me the para. Where is it here? My lord, this screen is becoming too small for me, my lord. Please, yeah, what is all this? You should have linked this. Yeah. You have not linked any of the cases. My lord, 2014, 14 SCC 731. Copy also? You have another copy? Other side.
Kulja.
What is this you're giving? It's not Kulja. 2014. Yes, my lord. Kindly, my lord. My lord, kindly come to paragraph 17 first, my lord, page 740. My lord, kindly take my lord, placitum B.
Yes.
Between two private parties, the right to take any such decision is absolute and untrammeled by any constraints whatsoever. The freedom to contract or not to contract is unqualified in the case of private parties. But any such decision is subject to judicial review when the same is taken by the state or any of its instrumentalities. This implies that any such decision will be open to scrutiny, not only on the touchstone of principles of natural justice, but also on the doctrine of proportionality. A fair hearing to the party being blessed thus becomes an essential precondition for proper and a valid order of backlisting made pursuant thereto. The order itself being reasonable, fair, and proportionate to the gravity of the offense is to be examined. Now, my lord, the next paragraph. Which one? My lord, 26, my lord. Kindly see this, my lord, page 744.
Yes.
In the case at hand, according to the respondent BSNL, the appellant had fraudulently withdrawn a huge amount of money, which was not due to it in collusion and conspiracy with officials of respondent corporation. Even so, permanent debarment from future contract for all times to come may sound too harsh and heavy a punishment to be considered reasonable, especially when appellant is supplying bulk of its manufactured product to the respondent and excess amount received by it. The next question then is whether this court ought to itself determine the time period or remit the matter back to so and so. Remand back to the competent authority is appealed to us to be a more appropriate option than an order by which we may ourselves determine the period for which the appellant would remain blacklisted. We say so for two precise reasons. Firstly, because blacklisting is in the nature of penalty, the quantum whereof is a matter that rests primarily with the authority competent. In the realm of service jurisprudence, this court has no doubt cut short the agony of a delinquent employee in exceptional circumstances to prevent. Secondly, because while determining the period for which blacklisting would be effective, the respondent corporation may, for the sake of objectivity and transparency, formulate broad guidelines to be followed. Different periods of debarment depending upon the gravity of the offences violation may. While it may not be possible to exhaustively enumerate all types of offences and acts of or violations of contract, the respondent corporation may do so as far as possible to reduce, if not totally eliminate, arbitrariness and inspire confidence in the fairness which they may pass against a defaulting contract. So, my lord, here, my lord, proportionality, my lord, was one aspect. And second, my lord, court did not, my lord, go in and said that I will determine it gave its reasons. Now, my lord, kindly take the next case. My lord, isolators case, my lord. That's, my lord, 2023. Eight Supreme Court cases now. 607. My lord, 38.1. The first and foremost being that in the 38, as regards the question, we find force and substance in the contentions urged on the appellant that such an imposition cannot be approved for two major factors. The first and foremost being that in the show cause notice, appellant was put to notice only as regard the proposition of debarment and nothing was indicated about imposition of penalty. Then, my lord, 38.2. Secondly, the authority concerned has proceeded to impose maximum of penalty to the tune of 10% without specifying as to why maximum of penalty was sought to be. In these relevant factors, as indicated by the appellant, could not have been ignored altogether. Unfortunately, has failed to consider that. Then, my lord, para 40. Even the order debarring the appellant for a period of 3 years for default in making requisite supplies, as notice, has indeed made substantial supplies. Fact of the matter remains that respondent number 2, dealing with procurement, specifically informed the appellant that supply has in question is to be. It has rightly been argued on behalf of the appellant that after such an order of deferment, there has not been any other communication or even etc. Then, my lord, kindly take, my lord, the last, my lord, Placitor me. My lord, just 5 lines, my lord, 2 lines above it, or along it, that being the position, we are clearly of the view that debarment order had been issued without due regard to undeniable factual situation where hence the impugned order. Of course, here, my lord, it was set aside, my lord, in its entirety. Now, my lord, where, my lord, blacklisting cannot lead to, my lord, closure, my lord, of, my lord, business. My lord, I rely on UMC Technologies. That's 2021. To SCC 551. That's the show called penalty of 2 years. My lord, paragraph, my lord, 14, my lord. Specifically in the context of blacklisting of a person or an entity by the state or state, requirement of a valid, particularized and unambiguous show cause notice is particularly crucial due to severe consequences and stigma. Here it may be gainful to describe the concept of blacklisting, graveness of blacklisting has the effect of denying a person or an entity the privileged opportunity. This privilege arises because it is the state who is the counterparty, and as such, every eligible person is to be. Not only does blacklisting take away this privilege, it also tarnishes the blacklisted person's reputation and bring. Blacklisting also has long lastings for future business prospects. The present has submitted that serious prejudice has been caused to it due to the corporation's order, and several other government corporations have now terminated with the appellant, prevented the appellant from participating in future tenders, even though impugned right was in fact limited to corporations, Madhya Pradesh region. So, my lord, this has happened here. My lord, the blacklisting order is for, my lord, dealing with them. But, my lord, wherever I'm going, my lord, I am being told you have a banning order. We will not. And this is what has happened. The domino effect, which can effectively lead to the civil death of a person, shows that consequences of blacklisting travel far beyond dealings with one particular government. And in view thereof, this court has consistently prescribed strict adherence to so and so. Severity and resultant need strict observance before passing an order, etc. Now, my lord, what are the account? My lord, court, huh? It said so, no? Now, my lord, I'll come to, my lord, blacklisting cases where, my lord, there has been, my lord, reduction, my lord, in the period. Yeah, 1 minute. My lord. My lord, first is, no, I don't want to give the employee cases, no. My lord, kindly take, my lord, 2013 SCC Online Delhi 679. My lord, paragraphs 29 to 32, and my lord, at my lord 32, my lord, your lordship will find, my lord, period of ban, my lord, was reduced from 5 years to, my lord, 2 years. Now get that. My lord, that was Justice Manmohan Singh. This is Justice Manmohan. My lord, paragraph 17 to 20. My lord, I am, my lord, only showing, my lord, that the court can, my lord, also reduce taking facts and circumstances into consideration. And my lord, para 17 to 20, my lord, here, my lord, lordship will find, my lord, Kulja is considered. My lord, the earlier Delhi High Court judgment, Sai Consulting is considered. And my lord, after taking, my lord, 17 is the proposition. Court is in agreement with contention for the punishment of debarment for a period of 1 year is not proportionate to the facts of the present case. This test of proportionality, my lord, is applicable for banning orders, and my lord, court can go into it. And here, ex facie, my lord, no loss, my lord, caused. My lord, why, my lord, then maximum penalty? And even on gravity, it doesn't equate to maximum because you're letting the running contracts, my lord, go. And my lord, there's one decision, my lord, which I wish to cite, my lord, that, my lord, here, my lord, 2 opportunities, my lord, were given. My lord, to, my lord, the concerned authority, and yet, my lord, concerned authority, my lord, has not, my lord, acted correctly. My lord, this is 1986, 2 Supreme Court cases, 679. Kindly see, my lord, para 80. Lordship has that, my lord, para
Yes.
18691. The first contention urged by learned counsel for the appellants was that the division bench of the High Court could not issue a writ of mandamus to direct a public authority to exercise its discretion in a particular manner. There is a basic fallacy underlying this submission, both with respect to the order of the division bench and the purpose and scope of the writ of mandamus. The High Court had not issued a writ of mandamus. A writ of mandamus was the relief prayed for by the respondents. What the division bench did was to issue directions to the appellants in the exercise of its jurisdiction under Article 226 of the Constitution. Every High Court has the power to issue to any person or authority, including in appropriate cases, any government throughout the territories in which it exercises so and so for enforcement. In Dwarkanath, this court pointed out that Article 226 is designedly couched in a wide language in order not to confine the power conferred by it only to the power to issue prerogative writs as understood in England, such wide language being used to enable high courts to reach injustice wherever it is found and to mold the reliefs to meet the peculiar and complicated requirements in this case. Court held that powers of the Miller kindly come to paragraph 20. There is thus, Miller, page 692
Yes.
bottom. There is thus no doubt that high courts in India exercising their jurisdiction under 226 have the power to issue a writ or to pass orders and give direction where the government or a public authority has failed to exercise or has wrongly exercised direction conferred upon it by a statute or a rule or a policy decision of the government, or has exercised as discretion malafide or on irrelevant considerations or by ignoring relevant considerations and material, or in such a manner as to frustrate the object of conferring such discretion or the policy for implementing which such discretion. In all such cases, and in any other fit and proper case, a High Court can, in the exercise of its jurisdiction under Article 226, issue a writ of mandamus or a writ in the nature of mandamus or pass orders and give directions to compel the performance in a proper and lawful manner of the discretion conferred upon the government or a public authority. And next is, and in a proper case, in order to prevent injustice resulting to the concerned parties, the court may itself pass an order or give directions which the government or the public authority should have passed or given had it properly and lawfully exercised. So, my lord, what the authority can do, my lord, even the court can do. In a given case, I'm not saying, my lord, every case, but here, my lord, there have been two, my lord, requests, my lord, by, my lord, the court. My lord, those are.
Quite a few judgments have been cited. I'll have to try to deal with them here. But my lord, at the outset, well, if your lordship sees, well, at the present moment, we are concerned with a situation where the banning order is accepted. My learned friends had initially come up, my lord, seeking to challenge the banning order. Now, the banning order naturally proceeded on the gravity of the offense. There is a Make in India policy. The Make in India policy is, my lord, a policy which is being pursued with vigor by the government. It is now a part of the public procurement process. And so far as this policy is concerned, well, today, for violation of these policies, there are consequences provided. Well, I shall take your lordship through some of the relevant provisions. But, my lord, what is very important is at the end of the day, my learned friends themselves give up their challenge to, my lord, the banning order. My lord, now, my lord, the order, my lord, which really ultimately said confine your attention only to the period of banning. Well, that is the order of 10th April 2005, which your lordship has been shown. Well, that ultimately says, my lord, consider the period, and my lord ultimately reflects on, my lord, what is stated in the policy document, that there are two considerations. It says that gravity of offense and loss. Well, these are the two considerations. Now your lordship is, my lord, well aware of the my lord, the principle that, my lord, today, well, the court did not ultimately by itself go into, my lord, introspect into what is the real meaning of this purpose. The court did not go into, my lord, the various, my lord, procurement documents, policies, GFR, etc., to understand what would be the gravity of offense, which would mean, my lord, essentially, that no matter how grave the offense is, maximum period of ban cannot be imposed. And my lord, so far as the question of loss is concerned, my lord, here the reflection is of financial loss. But my lord, loss can be also, my lord, other than financial loss. My lord, what is the loss here that has been ultimately portrayed or projected? And my lord, that has not been questioned. My lord, now my lord, Dunford has, my lord, ultimately accepted that, my lord, today, my lord, by reason of, my lord, the misrepresentations made or the wrong declarations made or the wrong impression created, well, ultimately he has procured for himself orders worth 230 crores, which he should not have otherwise got, which should have otherwise, my lord, been distributed. Now, my lord, one of the things the lordship has been told is there are no complaints. My lord, complaints were made to the ministry. This is what activated the whole process of inquiry. Now, my lord, today, my lord, without a complaint, my lord, this is not something that usually comes about. Now, my lord, it is only, my lord, because, my lord, parties are involved in the processes, and, my lord, they are regular participants in the tenders, that, my lord, they have decided not to bring action. But, my lord, the fact is that they could have brought action, because ultimately the public procurement process is vitiated. My lord, the public procurement process has been, my lord, ultimately taken for a ride. Now, my lord, your lordship has been told two things. The offence is grave, but not so grave. Why? Because you have continued with my subsisting tender. Well, that is a provision that is available, my lord, in the rules itself. I should show you, lordship. And, my lord, to undo, my lord, the process that has already started and against which supplies have been received, my lord, substantially, that would mean, my lord, taking the entire, my lord, process back, which would create untold difficulties for, my lord, the coal company itself. So, my lord, that itself cannot, my lord, ultimately undermine the gravity of the offence. And, my lord, there is a provision for the rules. And, my lord, what does it say? Ultimately, it says, my lord, two things: gravity of the offence and loss, which means that, my lord, no matter how grave the offence is, I cannot ban you for the maximum period of 2 years. That is, my lord, essentially the submission. It must also be accompanied by a loss. Now, my lord, the loss of reputation is also a loss. A loss of, my lord, integrity of the process is also the loss. But, my lord, what we have said is we have not suffered a financial loss. My lord, because the financial loss cannot be ascertained, my lord, unless the system itself is collapsed. My lord, that is, my lord, the long and short of the whole matter. Now, my lord, when your lordship, my lord, is taken through the documents, my lord, may I just show your lordship, my lord, first, my lord, two things. First is, my lord, the purchase manual. The purchase manual takes into account, my lord, the GFR, which is General Financial Rules. Now, my lord, what is the purchase manual, my lord, here, my lord, ultimately designed for, and what is it, my lord, purpose that is subserving? Please see page 466, which is a volume 3. My lord, will kindly have a look at, my lord, 492, my lord, which has been partially placed by my learned friend. Now, my lord, please see 6.13.2.
Yes.
Well, may I just read this? When the misconduct and moral turpitude of a firm goes beyond mere performance issues, imposition of a ban on business relations with the firm may be done for a specified period of time after following the prescribed procedure. The name of the defaulting firm from the list of registered vendors should be removed before submitting the proposal for banning of business. An order for banning passed for a certain specified period shall be deemed to have been automatically revoked on the expiry of that specified period, and it will not be necessary to issue a specific formal order of revocation, except that an order of banning passed on account of doubtful loyalty to the country or national security considerations shall continue to remain in force until it is specifically revoked. However, the firm would have to apply afresh for registration, etc., etc., etc. Now, my lord, your lordship will kindly pause here for a moment. My lord, here, my lord, the banning of business is contemplated on, my lord, misconduct and moral turpitude of a firm. My lord, when we talk about loss, my lord, loss is not definite, my lord, loss is not deliberately woven into the fabric, because, my lord, loss may be a consequence, but, my lord, that would not, my lord, ultimately impair, my lord, the right to, my lord, ban a business, because ultimately, what is the object? The object is not to stop your business forever. The object is to, my lord, put you under suspension of a particular period, so that it is a lesson to you and, my lord, also a message to all others. My lord, that is the whole object. And, my lord, that is why, my lord, the courts have made, well, including in the judgment that my learned friends have shown, have made a distinction between a breach of a contract and, my lord, something that ultimately answers, my lord, the misconduct or moral turpitude. My lord, courts have now held, my lord, including a very recent judgment, I think it's Justice Vishwanathan's judgment, my lord, where, my lord, the courts have held that no, you must make a distinction that I have not been able to perform the contract according to the terms, so you ban me. No. The consequence, you may suffer loss and damage, you may recover that. But that is not going to, my lord, ultimately answer banning. Banning must follow, my lord, what is, my lord, my lord, overreaching the entire process of the business, and, my lord, something that is a misconduct that disturbs the integrity of the process. Now, my lord, so far as this is concerned, the reason why I show this to your lordship, 6.13.2 is your lordship will not find here, my lord, anything in particular which talks about loss. Kindly, my lord, come down the page. Then, my lord, 6.13.2, Roman 1. If the directors, proprietors, employees, partners, or any representative of the firm is or are found guilty of offences involving security consideration, not required, then director, proprietor, partner, manager, or representative firm is convicted by a court of law, not required. Then, my lord, please see Roman 3. Violation or transgression of the integrity pact. Well, this is what we are concerned with. Now, my lord, if there's violation or transgression of the integrity pact, then, my lord, it can lead to banning. And, my lord, the period of banning is not proscribed here, my lord, by saying it must also be accompanied by financial loss. My lord, the reason why I say this, my lord, I shall have to interpret, my lord, what is meant by that language. And, my lord, for that one needs to look into the background. My lord, thereafter, your lordship will kindly have a look at, my lord, one more, my lord, provision here of the purchase manual. My lord, now, my lord, if your lordship will have a look at, my lord, Roman 6 at page 493. My lord, here your lordship will find willful suspension of facts or furnishing of wrong information, false declaration, or manipulated or forged documents by the firm, or using any other illegal, unfair means. Is in itself enough to justify banning. Now, my lord, in this context, your lordship will please have a look at now 6.13.4. Period of banning or debarment. The period of banning should be decided based on the gravity of the offence and the quantum of loss suffered by CIL or its subsidiary quantities. Now, my lord, may I just pause here for a moment? My lord, does it mean that, my lord, today without, my lord, any financial loss being suffered or being quantified, a ban cannot proceed? Or, my lord, does it mean that, my lord, today if there is no financial loss suffered or immediately quantified, you must impose the minimum, my lord, ban? It could be for one day. How does, my lord, the authority of the court, my lord, decide on what is the period of ban which is to be imposed? And, my lord, here, well, the basis on which it was proceeded is that the contracts are biennial. If I don't bar you for one season, well, at one period or one, well, cycle of contracts,
It doesn't serve any.
then, my lord, I'm not really sending out a message. Now, my lord, so therefore, your lordship is ultimately, my lord, looking at whether, my lord, there is malafide. Because, my lord, the judgment that Mr. Mukherjee showed to your lordship, my lord, including the last judgment where, my lord, the doctrine of mandamus is discussed. My lord, paragraph 20, if I remember hearing him correctly, my lord, proceeded to say that it must be, my lord, malafide access. My lord, ultimately, your lordship must find that there is, my lord, a wrongful, my lord, nexus between, my lord, the purpose of banning and the period of banning. Now, my lord, here, so far as we are concerned here, ultimately, when my learned friend accepts the fact that, my lord, a banning is justified and only confines to the question of period of banning, now, my lord, here my learned friends will have to then, my lord, come to your lordship and say that no, the period of banning is, my lord, malafide. It has been maliciously imposed. Now, my lord, here, if your lordship will now please have a look at, my lord, the judgment and order of our court, my lord, which is the basis of the order, 10th April 2025 once. My lord, please let us understand what the court said, because, my lord, my learned friend has repeatedly said this is in violation of order of court. My lord, here the court never ultimately, my lord, proceeded to interpret the clause itself. My lord, please have a look at, my lord, page 689, paragraph 18. on just 1 or 2 paragraphs. Or, my lord, your lordship, my lord, need not consider 689. Please come straight away to, my lord, page 694. My lord, here the court is reading the clause literally without, my lord, application of mind as to what, my lord, the clause really, my lord, provides for. The ground for which the petitioner has been banned, that is submitting false declaration or certificate, carries a maximum ban for a period of 2 years. The period of ban is to be decided based on the gravity of the offence and the quantum of loss suffered by CIL. Well, because this is the clause, but my lord, your lordship has seen that the preceding clauses provide for banning irrespective of whether financial loss has been suffered or not. Then, the petitioner alleges that the principle of proportionality while imposing punishment has been ignored. Now, my lord, pausing here for a moment, Mr. Mukherjee has said that, my lord, see, I have exceeded or fallen short of the requirement of, my lord, making a policy by only a short margin. But it's not a matter of short margin or long margin. The question is whether you would have been qualified to, my lord, ultimately bid for, my lord, the quantities that you bid and was awarded, or you would not have qualified. The question is, therefore, my lord, is someone else who ultimately fulfills, my lord, the Make in India policy, my lord, requirements, is, my lord, deprived? That is the question. And, my lord, that is where, my lord, the gravity of the offence sounds, my lord, very ominously, because, my lord, ultimately, this is subversion of the, my lord, public procurement system itself. Now, my lord, if your lordship sees, my lord, is it really a violation of the order of court? Admittedly, in the instant case, the chairman CIL in the impugned order has mentioned about the reasons for banning the petitioner, but has not given any reason as to why the ban is to impose for the maximum period. My lord, that reason is not supplied, my lord, with reasons. The impugned order also does not mention as to whether CIL or any of its subsidiaries suffered any loss on account of submission of false declaration by certificate. Because that is a point that is, my lord, urged, because on a literal reading of the clause. The authority may not accept the explanation or the interpretation given by the petitioner as regards the certificate relied upon by it. But the authority would be required to give reasons as to why the maximum period of ban is to be imposed. Now, my lord, one has to find that these reasons are malified. Then, the very fact that the tender document prescribes only the outer limit of the ban period but does not stipulate a fixed time period for the ban to be applicable implies that there is scope for banning an offender for a period less than the prescribed outer limit. Absolutely. Well, no quarrel with this. Had the tender document specified that for the subject offence the ban shall be applicable for a period of 2 years, then there would not have been any scope for reduction of the ban period. However, since the tender document prescribes that the ban period shall not exceed 2 years, the same gives an indication that in a given case, the ban period may be less than 2 years. It is not mandatory that in each and every case where an offence is detected, the offender has to be mandatorily banned for a maximum period of punishment. Chairman appears to have missed out on this aspect of this period of ban. Period of ban is to be decided on 2 factors. Firstly, the gravity of the offence, and secondly, the quantum of loss suffered by CIL of the subsidiary companies. In the impugned order, there is no reflection as to whether the period of ban has been decided, keeping in mind the aforesaid 2 factors. Now, my lord, both these factors are reflected upon in the, my lord, order that is presently under challenge. And, my lord, we have said as to why, my lord, although no financial loss has been suffered, there is justification for, my lord, imposing a 2-year ban. And, my lord, we have also said that if a 2-year ban is not imposed, you are not even barred from one solitary cycle. Now, my lord, if you break up a contract into 2 parts, that one for cartridge, one for bulk, and I've already been banned for cartridge because 1 year has elapsed, my lord, how will your lordship then decide that what is, my lord, appropriate? My lord, today, where it is manifest that there is, my lord, a malafide, my lord, in play, or my lord, there's some malafide action or intention, then, my lord, of course, the court will intervene. But, my lord, here there's no allegation of malafide. And, my lord, this is also more apparent from the fact that, my lord, here, because, my lord, this is a person who has been, my lord, a supplier to the Coal India Limited or Mahanadi Coalfields Limited for a long time, my lord, that we have not stopped his supply. But we have said that there must be some imposition, because otherwise it is going to send a completely wrong message to the entire, my lord, procurement system and those ultimately who participate in it and the stakeholders. Now, my lord, the question is, my lord, here 2 things your lordship will have to, my lord, consider as to whether, therefore, there was a mandate imposed by the court to interpret, my lord, ultimately the procurement policy or, my lord, the policy, my lord, which have been relied on, my lord, in the context of there must be a loss. Now, my lord, I'll answer it from 2 perspectives. Let us, my lord, resume for the sake of argument. First, my lord, taking the argument against myself. That, my lord, the clause read, my lord, very literally at 6.13.4. And, my lord, the order of the court, my lord, which also proceeds to, my lord, ultimately look at the clause literally, is something that fetters. Said that you must also consider a loss. Now, my lord, the loss is to be considered to be determine the extent of the period of banning. Now, my lord, it does not anywhere say as to, my lord, how it will impact the period. And, my lord, given the fact that, my lord, otherwise, my lord, loss is not, my lord, something on which independently a banning can proceed. My lord, the question is how much, my lord, weightage will one assign to the loss? My lord, may I just clarify myself, my lord, a little more? My lord, here, my lord, if it had only been loss suffered, let us say, my lord, the actions of the contract have caused the loss to Coal India. Would that be cause for banning? With the greatest respect, no. That would not have by itself, my lord, been a cause for banning, could not have been a cause for banning. And particularly in the light of the decisions which are now, my lord, holding the field, my lord, if today you have by your consequences, my lord, caused a loss, then, my lord, it can be recovered by way of damages. So, my lord, if today loss by itself cannot, my lord, justify banning, then the question is how much weightage will one have to ultimately put to, my lord, the element of, well, lord, no financial loss has been suffered in determining the period of banning. And, my lord, here your lordship has already seen, my lord, I have shown your lordship, my lord, the purchase manual, and, my lord, how the manual proceeds. The manual does not say that in case you have caused loss and loss alone, without anything else, there can be a justifiable, well, a reason to ban a contractor. Now, my lord, will lordship please now have a look at the GFR, which my learned friends, my lord, referred to. These are the general financial rules.
Yes.
Your lordship has been showed 151, rule 151, that your lordship will find at, my lord, page. What number page is it? No, I'm sorry, my lord. Your lordship has GFR here. Now, my lord, your lordship will kindly see. Well, your lordship has been handed up a copy of the GFR.
Yes.
Please see rule 151 once.
Yes.
Debarment from bidding. A bidder shall be debarred if he has been convicted of an offence under the Prevention of Corruption Act, Indian Penal Code. My lord, a bidder debarred under section such and such shall not be eligible. My lord, then rule 3. A procuring entity may debar a bidder or any of its successors from participating in any procurement process taken by it for a period not exceeding 2 years if the ministry determines that the bidder has breached the code of integrity. My lord, what I am, my lord, on is, my lord, therefore, my lord, simplicity of causing loss is not a ground for banning. But, my lord, if you have breached the code of integrity, then that is, my lord, ground for banning. And, my lord, this again, my lord, must reflect on whether and if so, to what extent, my lord, non-causation of loss will reflect on the period of ban. Now, my lord, we'll also have a look in this regard to, my lord, the other provision which my learned friend drew your lordship's attention to. Well, that is, well, I think 175(1). Well, this is the code of integrity. Well, kindly see. Well, no official or a procuring entity or a bidder shall act in contravention which does not include, etc., etc. My lord, it is all, my lord, given here. Now, my lord, your lordship will kind to come to H, clause H of, my lord, 175(1). And, my lord, here making false declaration or providing false information for participation in a tender process to secure a contract. Now, my lord, this, my lord, integrity process, my lord, which has been highlighted in the GFR, my lord, in the procurement, in the purchase manuals, my lord, has to have some sanctity. And now, my lord, if your lordship will kindly have a look at the NIT, my lord, which is the term on which my learned friends now rely. Now, my lord, please have a look at the NIT that your lordship will find, my lord, talks about eligible bidders at page 110. And, my lord, here highlighted on the basis of, my lord, the policy decision of the government, which is also reflected in the GFR and in the purchase manual. Well, let please see clause 6. Purchase preference under Make in India policy. Internal under Make in India policy of the Government of India, purchase preference will be given to eligible bidders as per public procurement, reference to Make in India Order 2017, subsequently revised on such and such. And then your Lordship will kindly have a look at 111. Well, there's a distinction made between class 1, class 2 and non-local suppliers. Class 1 local suppliers, your Lordship will find, means a supplier whose goods and or services offered for procurement has local content equal to or more than 50%. Class 2 local supplier means a supplier whose goods and or services offered for procurement has 20% or more local content but less than 50%. Non-local supplier means a supplier whose goods and or services offered for procurement has local content of less than 20%. Local content means the amount of value added in India, which shall be the total value of the item procured, excluding net domestic indirect taxes minus the value of imported content in the item, etc. As per Office Memorandum dated 4th March 2021, it has been clarified by the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, that bidders offering imported products will fall under category of non-local suppliers. They can't claim themselves as class 1 local suppliers or class 2 local suppliers by claiming the services such as addition of inputs like transportation, insurance, installation, commissioning, training and after service will not be local value addition. In view of the above, local content will not include services such as transportation. Then, my lord, verification of local content, how this is to be done. And my lord, I will not trouble your lordship with all of that, but please come to my lord Roman 2D. False declarations will attract banning of business of the bidder or its successors for a period up to 2 years, along with such other actions. The false declarations in itself can attract a banning of up to 2 years. Does not have to be accompanied by loss. And this is a part of the NIT. NIT is the document under which the bids are being processed and also made. Now, this part, your lordship will please have a look at now. 131, instruction to bidders. Clause 36 of the NIT.
Yes. Banning of business, my lord, includes in Roman 6 willful suppression of facts or furnishing wrong information, false declaration or manipulated or forged documents by the firm using any other illegal unfair means. And then, my lord, your lordship will find, my lord, at the bottom of the page, the period of banning shall be decided based on the gravity of the offence and the quantum of loss suffered by CIL or the subsidiary companies. In case banning under subclauses 1, 2 and 3 above, the banning period shall not exceed 3 years. In case of banning under subclauses 2, banning period shall not exceed 2 years. Now, my lord, pausing here for a moment, in this background, your lordship will kindly consider, my lord, what would be the impact of, my lord, here, the writing at the bottom of this, my lord, where the banning need not proceed on, my lord, a loss at all, or, my lord, cannot proceed simpliciter on a loss. My lord, what would be the import of, my lord, this term? And, my lord, if at all your lordships are of the opinion that, my lord, this is something that, my lord, is a necessary concomitant of, my lord, the order of banning, then, my lord, today can a product be or a manufacturer be banned or a supplier be banned? Because, my lord, there is no loss cause. And if so, can it be banned for the entire period, or, my lord, it must be reduced? And if so, to what extent? There is no such guideline there. Ultimately, my lord, here your lordship has seen the emphasis throughout is the Make in India policy, identification suppliers as class 1, class 2 non-local suppliers. And, my lord, it is that policy which is, my lord, a part of the integrity process of the integrity code, which cannot be violated. And, my lord, although, my lord, this is a trusted supplier, although, my lord, we have chosen to continue with his contract, my lord, which is also permissible, I should show your lordship that, my lord, it does not mean that, my lord, he cannot be visited with, my lord, the maximum penalty, because, my lord, ultimately, my lord, as we've tried to explain in the banning order, if the maximum penalty is not imposed, then he might not suffer the consequence of ban for even one cycle of business. And that is how it has been explained.
Now, my lord, so far as this is concerned, may I just, my lord, show you, lordship, my lord, the general conditions of contract now, my lord, a part of the NIT, page 150. My lord, this is, my lord, the provision which makes the purchase manual applicable to the NIT. Now, I've shown you, lordship, the purchase manual. Clause 30. The provisions of CIL's purchase manual and its subsequent amendments shall also be applicable if not specified otherwise in the bid document. Well, now, my lord, with the greatest respect, my lord, if one now looks at, well, the whole, my lord, purpose of the Integrity Pact, and, my lord, the whole object of banning, my lord, if amongst other things false declarations are made, Integrity Pact is compromised, orders are, my lord, procured to which otherwise, my lord, a contractor is not eligible, then, my lord, the question is, my lord, there will have to be a ban. And, my lord, so far as that ban is concerned, my lord, the loss, my lord, that is caused, my lord, may or may not be relevant. My lord, this may be an additional factor to ban. By itself, my lord, it cannot, my lord, compromise the order of banning or, my lord, compromise the period of ban. My lord, that is what I am trying to say. Now, my lord, and in this regard, when your lordship is looking at, my lord, the order of, my lord, 4th October, 10th April 2025, the order says look into the policy, look into the clauses and then decide. It does not say that, my lord, ultimately, unless there's a loss suffered, you can't ban. Or if there's a loss suffered, you can ban only for a particular period and not more than that. Well, here you'll also find that there are decisions which have said that unless, my lord, the court finds that there is malafidus in, my lord, administrative action, well, the court does not normally interfere. And, my lord, so far as this is concerned, now, my lord, if your lordship now looks at, my lord, first, my lord, two lines that I will pursue here. Number one is, my lord, it is very well settled now that, my lord, where the word, my lord, and this is in the domain of contracts as well, not only statutes, where the word, my lord, and is used and can mean, my lord, or as well, and or. My lord, Supreme Court, my lord, in several decisions has said that. I shall just by way of, my lord, example, or, my lord, just by way of clarity, my lord, give you lordship one or two judgments. My lord, please have a look at it. Copy down. 2008 volume 4 Supreme Court cases, page 755. This is the Gurja case. My lord, this is a popular case in insolvency, my lord, bankruptcy now. Gopal Ganj আরে আমার কাছে নিউ কপি আছে No, it's not that one. It is another. You're right. This is not that judgment. Well, Lord, may I request your lordship to kindly have a look at, well, Lord, paragraphs 26 and 27. I mean, I also want to took it for granted. This is that judgment.
My learned friend, my lord, mentioned the name. My lord, he said, my lord, that this is very commonly cited in insolvency cases.
Yes, that thick one.
That's a thick one, my lord, by Justice Chandra.
Well, I
Not this
realized, well, as soon as he was handed up this copy, that this is not the same Gujarat Urja. Well, Lord, we make some presumptions, well, Lord, which are not always correct. Well, Lord, paragraphs 26 and 27. It may be noted that section 86(1)(f) of the Act is a special provision for adjudication of disputes between licensee and generating companies. Such disputes can be adjudicated either by the State Commission or the person or persons to whom it has been referred to arbitration. In our opinion, the word "and" in section such and such between the words generating companies and to refer the dispute for arbitration means "or." It is well settled that sometimes "and" can mean "or" and sometimes "or" can mean "and." In our opinion, section 86(1)(f) of the Electricity Act, the word "and" between the words generating companies and the words refer as disputes means "or," otherwise it will lead to an anomalous situation because obviously the State Commission cannot both decide a dispute itself and also refer it to some arbitrator. Well, I pause here for a moment. The reason why I cite this judgment is only to amplify this. Well, if today loss is not a reason for banning, or a justification for banning, and the banning can proceed independently of loss. Then the question is, when you use the word and in the clause which your lordship seen, it must be read as and or, because it is in addition that the loss may be caused. Not as if loss has to be independently there to either justify banning or to decide on the quantum of period of ban. And then again, the question is, in the absence of any allegation of malafide, of which my learned friend has very in his usual fairness not made any reference. Well, the question is, to what extent then will your lordship then decide what should be the quantum of period of ban? Well, there are other judgments also, similarly, but I don't want to trouble lordship because the proposition is clear. Secondly, the second line, which I would like to, ultimately urge before your lordship, is that, when your lordship ultimately looks at, the contract, a tender, now, your lordships have settled the law very clearly that, in interpreting a tender, the best interpreter of the tender terms is, the tenderer itself. Now, today, I would be also, subject to your lordship's, scrutiny if your lordship found that my actions were malafide. But when I read, the procurement policy, when I read the GFR, when I read the NIT, and I show to your lordship that, ultimately, it is the integrity process which is, of significance, which is, supposed to be sacrosanct, which is supposed to be followed and not be departed from or deviated from. Then the question is, will your lordships now, say that the state or the administration or the tenderer is acting in a malafide fashion by reading the expression and as and or? Just again, by way of example, may I just cite before your lordship, 2022. The judgment of NG projects, this is 2022, volume 6, Supreme Court cases 1 to 7. Gopal, please see, this is also very well established now. Paragraph 12, if your lordship will see first. Talks about AFCONs, which is now the leading case on the subject. In AFCONs Infrastructure Limited versus Nagpur Metro Rail Corporation, this court held that the owner or the employer of a project having authored the tender documents is the best person to understand and appreciate its requirements and interpret its documents. Then, this is reproduced. And this your lordship will again find, judgments are referred to, the entire line of authorities is, considered in this regard. Then please see paragraph 17. Therefore, the position of law with regards to the interpretation of terms of the contract is that the question as to whether a term of the contract is essential or not is to be viewed from the perspective of the employer and by the employer. Now, what is the term here? If the NIT is the term of the contract, and loss. Now, do I, then, have the liberty or, the leeway of, interpreting it in that fashion, and would that interpretation be a deliberately wrongful, arbitrary, or malafide interpretation? And similar paragraphs, I don't want to trouble your lordship because I'm only citing this for a proposition which is otherwise very well established. Now, coming to the judgments which my learned friend has relied on. He first, cited Kulia. Yeah? Yes, two more. I'm sorry, two more judgments before I come to Mr. Mukherjee's judgments. I should have shown this. There are two other judgments I'd like to show to your lordship as to when the court interferes. 2000 volume 1, 2001 volume 2, Supreme Court cases 386. Well, your lordship might find the name a little familiar. Please see paragraph 53 onwards, and then a couple of paragraphs. Now, under Articles 19(2) to 6, restrictions on fundamental freedoms can be imposed only by legislation. In cases where such legislation is made and the restrictions are reasonable, yet, if the statute concerned permitted the administrative authorities to exercise power or discretion while imposing restrictions in individual situations, question frequently arises whether a wrong choice is made by the administrator for imposing restriction, or whether the administrator has not properly balanced the fundamental right and the need for the restriction, or whether he has imposed the least of the restrictions or the reasonable quantum of restriction, etc. In such cases, the administrative action in our country, in our view, has to be tested on the principles of proportionality, just as is done in case of main legislation. This, in fact, is being done by our courts. Administrative action in India affecting fundamental freedoms has always been tested on the anvil of proportionality in the last 50 years, even though it has not been expressly stated that the principle that is applied is the proportionality principle. For example, a condition in a license issued to a cinema house to exhibit at every show a certain minimum length of approved films was questioned. The restriction was held reasonable, then reference is made to decisions of the court, also related inter alia to the validity of licensing conditions. In another case, an order refusing permission to exhibit a film relating to the alleged obnoxious or unjust aspects of reservation policy was held violative of the freedom of expression. Cases of surveillance by police came up for consideration, such and such. These examples are given. Then, if your lordship will please see, paragraph 56. Paragraph? Straight away kindly come to paragraph 71. I don't, the 70 and 71, all the cases are discussed on the subject. In this context, we shall only refer to these cases. In Ranjit Thakur versus Union of India, the court referred to proportionality in the quantum of punishment, but the court observed that the punishment was shockingly disproportionate to the misconduct proved. In BC Chaturvedi versus Union of India, this court stated that the court will not interfere unless the punishment awarded was one which shocked the conscience of the court. Even then, the court would remit the matter back to the authority and would not normally substitute one punishment for the other. However, in rare situations, the court could award the alternative penalty. This was so stated in Ganayuntham. Thus, from the above principles and decided cases, it must be held that where an administrative decision relating to punishment in disciplinary cases is questioned as arbitrary under Article 14, the court is confined to the Wensbury principles as a secondary reviewing authority. The court will not apply proportionality as a primary reviewing court because no issue of fundamental freedoms nor the discrimination under Article 14 applies in such context. The court, while reviewing the punishment, and if it is satisfied that Wensbury principles are violated, it has normally to remit the matter to the administrator for a fresh decision as to the quantum of punishment. Only in rare cases where there has been a long delay and in the time taken by the disciplinary proceedings and in the time taken in the courts, and such extreme or rare cases can the court substitute its own view as to the quantum of punishment. Well, I'll not trouble your lordship with the rest of it. Then, my lord, one more judgment only. Well, this is 2022 judgment. Yes, Mano Govinda Shamakar. Well, this is 2022 Supreme Court cases online, SC 284, paragraph 9 onwards, your lordship will kindly consider. Well, in fact, my lord, it is only the fifth, sixth line. Well, kindly see, my lord, starts with a sentence quantum of punishment at paragraph 9. Well, about 6 lines from the top of paragraph 9. Quantum of punishment is within the discretionary domain and the sole power of the decision-making authority once the charge of misconduct stands proved. Such discretionary power is exposed to judicial interference if exercised in a manner which is grossly disproportionate to the fault as the constitutional courts, while exercising the power of judicial review, do not assume the role of the appellate authority. Writ jurisdiction is circumscribed by limits of correcting errors of law, procedural errors leading to manifest injustice or violation of principles of natural justice. The decisions are also disturbed when it is found to be ailing with perversity. On the question of quantum of punishment, the court exercising the power of judicial review can examine whether the authority has been a reasonable employer and has taken into consideration measures, magnitude and degree of misconduct in all other relevant circumstances and excluded irrelevant matters. In the context of quantum of punishment, these aspects are examined to consider whether there is any error in the decision-making process. On the merits of the quantum of punishment imposed, the courts would not interfere unless the exercise of discretion in awarding punishment is perverse in the sense that the punishment imposed is grossly disproportionate. Clear from this. Can I improve that? Now, my lord, just one form, my lord, before my lord, we come back, my lord, to the cases that Mr. Mukherjee has cited. My lord, please once, my lord, have a look at the final banning order now. Once again. My lord, that is, my lord, at page 718.
Yes.
Your lordship will find, my lord, ultimately, skipping over everything else, my lord, everything has been discussed, my lord, in my lord, some detail. My lord, paragraph 6, your lordship will find in bold, where it proceeds on, my lord, the willful suppression of facts.
Yes.
Then, my lord, your lordship will skip over. My lord, kindly have a look at 721. My lord, as to why, my lord, the offense is grave. My lord, 721, your lordship will find.
Yes.
My lord, the offense committed by is grave in the following facts. My lord, that is, my lord, recorded. And then your lordship will find, my lord, we have stated that, my lord, how you have subverted the process by representing yourself to a class 1 supplier. And then, my lord, please see, it says from the above, it is clear that you have made offer and secured orders worth 230 crores, which should have been placed on other class 1 eligible local suppliers instead of you. And, my lord, now, my lord, we say that here, now please see the justification. My lord, subversion of the process, my lord, Mr. Mukherjee has placed most of it. I don't want to trouble your lordship. Then please see, my lord, once again, my lord, your lordship has seen this, but I want to trouble your lordship once again with this. 723, paragraph 3.
Yes.
Lord, kindly allow me to place the purpose of blacklisting of the contractor is to prevent it from the privilege and advantage of entering into a lawful relationship for a period of time in account of wrongful facts with the object of deterring the party concerned from committing any wrongful act in future, and also to serve as notice to others with the object of curbing wrongful unethical practices in the law. Actually give me a moment, but I find I'm running out of power. This has become. Oh. This has now become.
At least your lordship's court, my lord, has a charging system.
Suddenly you get a warning that low battery and your heart skips a beat. Take it for you. And my lord, now your lordship will see that, my lord, so far as here is concerned, the last portion of page 723. My lord, here, my lord, this is the justification. It says, though the specific quantum of financial loss arising from the misrepresentation cannot be ascertained precisely. Well, we are not saying that there is no loss at all, but we are not saying that, my lord, it cannot be ascertained precisely. The nature and gravity of the offence in this case is such that it strikes at the heart of the public trust in the governmental process. Considering the object to be achieved in the instant case, where the tender is floated on a biennial interval so as to act as a meaningful deterrent, which is required to uphold the integrity of government procurement processes. Clause 6.13.4 is required to be and is to be interpreted to mean that the period of banning has to be determined on the basis of the gravity of the offense and or the quantum of loss suffered. Well, I will not trouble your lordship with this entire text again because, my lord, it has been placed before your lordship. Now, my lord, coming to the cases which my learned friend has cited, the first decision he relied on was my lord Kulia. My lord, if your lordship comes back to my lord this judgment, my lord, this was a case of blacklisting forever. My lord, that your lordship will find, my lord, in the my lord head note itself. If your lordship will kindly have a look at my lord Placitum C at page 730. My lord, your lordship will kindly see. I don't want to my lord travel down the my lord paragraphs. It will take longer. The appellant contractor was blacklisted for drawing more money by submitting fake bills in collusion with some officials of the responding corporation. The appellant contractor informed the respondent corporation was ready for settlement and also ready for repayment of extra money received. Forever. I know my lord, that this case is a my lord, perpetual blacklisting case. I'm trying to find my lord, the post. Yes, my lord, last 4 lines of my lord Placitum, my lord, this is Placitum D at page 732. Thereafter, fresh proceedings were initiated. Does the lordship have my lord?
Yes,
Thereafter,
yes.
fresh proceedings were initiated by the respondent corporation by issuing notice to the appellant contractor. Upon receipt of reply, the
Forever,
respondent
yes.
contractor contract forever. Now, it is in this context, my lord, that the decision proceeded. And we ultimately said that, my lord, you have to apply the touchstone of, my lord, the 2 principles. One is natural justice and proportionality. It says, well, however grievous, my lord, may be the offense, ultimately you have to ultimately strike at a balance. You can't, my lord, deprive him from the right to, my lord, business forever. Well, that is, my lord, Kulja's case. And it, of course, my lord, ultimately is, my lord, a commentary on, my lord, the doctrine of, my lord, proportionality, particularly in the context of blacklisting. He said you must take a reasonable view of it. My lord, the next decision was isolators, my lord, which also, my lord, relied on Kulja. My lord, in isolation, your lordship will please have a look at. I think, my lord, paragraph 38 is what, my lord, showed. 38.1. My lord, I'd like to show you, lordship, my lord, paragraph 40 also. This, my lord, really sums up the whole thing. Yes, my lord showed 38.1 and 38.2. Also 40. My lord, kindly see 40. Well, let me
40
read
was
paragraph
also
40. Yes, my lord. My lord, before that, my lord, what my lord really is the basis of this judgment is paragraph 35, where it proceeds on the basis that there was no valid show cause notice at all. And my lord, that is where UMC technologies, which my learned friend cited, my lord, was my lord, referred. My lord, please see, my lord, UMC is referred to in paragraph 30, 35, and it says therein, this court entirely underscored the requirement of specific show cause notice and referred to the settled principles. Well, it is now, my lord, the question of, my lord, transgressing the limits of what is stated in the show cause notice is, my lord, well. Well, it is really, my lord, proceeds on that principle, and ultimately 38.1 and 2, which is relied on. Well, please see 38.1. The first and foremost being that in the show cause notice, Appellant was put to notice only as regards the proposition of debarment in the said notice. Nothing was indicated about the proposed imposition of penalty. Now, in our notice, my lord, proposed imposition of penalty was clearly mentioned. Then, my lord, 38.2. Secondly, the authority concerned had proceeded to impose the maximum penalty to the tune of 10% of the deficit supply without specifying as to why the maximum penalty was sought to be imposed. Now, my lord, here, now please look at paragraph 40. Well, this is what ultimately weighed with the court. Even the order debarring the appellant for a period of 3 years for default in making the requisite supplies carries its own shortcomings. Well, here the court is finding fault with the debarment itself. As noticed, the appellant had indeed made substantial supplies against the purchase orders in question. Fact of the matter further remains that on 18 September 2019, Respondent number 2 dealing with the procurement specifically informed the appellant that the supply under the purchase order in question is to be deferred. It has rightly been argued on behalf of the appellant that after such an order of deferment, there had not been any other communication or even indications from the respondents which would have informed the appellant to resume supplies. We have reproduced here and above all the relevant passages in additional written submissions on behalf of respondents made in effort, etc., etc. Then please come to Placidum E. I'll start with end of Placidum D. The written submissions on behalf of the respondents do not answer the root question in the matter as to how the appellant could have been made solely responsible for delay or default in supply after communication dated such and such, when the respondents themselves informed the appellant that taking of balance delivery was being deferred until further instructions. Well, this is what weighed with the court. And the court was ultimately looking at flaws in the decision to ban itself. This is isolators, and then what my learned friend cited was the question of domino effect of blacklisting. That is the 2021 two Supreme Court cases 551. Here reliance was placed on paragraph 14. Now today, so far as this is concerned, the question is we do not foresee at this moment as to how an order of banning passed in respect of one particular institution and restricted within the scope of tenders floated by that institution may reflect on other tenders. Now, very often, your lordship will find that the tenders will require a declaration. Have you been banned by any other? But that is, only a declaration. It is not, a disqualification. It is not as if, if you are banned, you can't participate in the tender or cannot submit your bid. Well, what my learned friend has said is that, this is what happens. But, yes, it is only a declaration that is required to be made, but it is not a disqualification per se. It does not prevent the party from participating. Now, the relevant paragraph which my learned friend placed from this judgment, paragraph 14, kindly have a look at that once. It says specifically in the context of blacklisting of a person or an entity by the state or a state corporation, the requirement of valid, particularized, unambiguous show cause notice is particularly crucial due to the severe consequence of blacklisting and the stigmatization that accrues to the person or entity being blacklisted. Here it may be gainful to describe the concept of blacklisting and the graveness of consequences occasioned by it. Blacklisting has the effect of denying a person or an entity the privileged opportunity of entering into government contracts. This privilege arises because it is the state who is the counterparty in government contracts, and as such, every eligible person is to be afforded equal opportunity to participate in such contracts without arbitrariness and discrimination. Not only does blacklisting take away this privilege, it also tarnishes the blacklisted person's reputation and brings the person's character into question. Blacklisting also has long-lasting civil consequences for future business prospects. But this is the general commentary. Now, what is important is, here again, the emphasis was on an unambiguous show cause notice and appropriate opportunity of representation. In this case, both afforded, and thereafter, following the directive of this honorable court, a more detailed reason given as to why it was considered relevant. And thereafter, your lordship has been shown the judgments in 2013 Supreme Court cases online Delhi, 2016 SCC online Delhi, where the court has taken upon itself the well, the task of reducing the quantum. Well, the question is, well, what objective parameter will your lordship employ in the facts of this case? Well, three answers. Well, one is, well, today, well, there is, well, really, well, no directive of the court to interpret the terms of the contract in a particular fashion. It only reproduces what the contract says. Two is, well, while interpreting the contract, well, the authority has taken into account, well, the real object of, well, the public procurement system and the, well, requirement of ultimately ensuring the purity of the procurement process. And it is in that light, well, that it has considered really the banning order. And, well, today, as I said, that independently of this, well, loss cause, well, will not justify or occasion a ban. So, well, the loss is only, well, an additional factor, which may ultimately determine the banning, but that does not mean that if there is no loss, you cannot ban for the whole period. So, upon applying the doctrine of interpretation to contracts where and in the context of situations can be read as or also, and further where the tendering authority is the best interpreter of what its intendment is in respect of a contract. With the greatest respect, there is no mala fide and none has been ascribed. It is only saying that you have not applied or read the contract as it is. Today the contract can be read literally, it can be read purposively, it can be read, upon harmonizing the previous clauses to, ultimately decide as to what would be intended. And, the absurdity would be this, that if one, is to ignore gravity of offense and only look at loss, that would not even justify a ban. This apart, the other submissions that have been made, are really, on, points of prejudice that, we fell short just by this much or that much. But that is not really of any relevance at this point in time, because at the end of the day, my learned friends, did not question or challenge the order by which, the banning order was upheld and, the matter was remitted back, only on considering the, purpose of, the period of, punishment. That is all. Let's just can you repeat what I said? These are really my suggestions.
May I quickly, deal with first point, my learned friend has taken. Is on the question of interpretation, that and should be read as and or is the sole prerogative of the tender issuing authority. And that this is a possible interpretation. I have 3 points to make there. First is this question of interpretation has been closed because of the order of the learned single judge. All parties have accepted it. There is no appeal from that. Number one. Number two, the decision which has been relied on, 2022 6 SCC 127 is here, the employer or the tendering authority, is the judge, of the terms of a tender, only for the purpose of selecting and determining the eligibility criteria. That's evident from the decision itself. Kindly take NG projects 2022 6 SCC. I will rely on my learned friend has relied on paragraph 12 and 17. Kindly come to paragraph 16. Lordship may note the paras I'll rely on. Para 16, 22 and 23.
Yes.
Now, kindly see para 16. In Galaxy, a 3-judge bench again reiterated that the authority that authors the tender document is the best person to do what? To understand and appreciate its requirements. I'm sorry, Your Lordship. And thus its interpretation should not be second best by a court in judicial review. It was observed thus. Now kindly take the quotation from Galaxy, which in turn quotes Jagdish Mandal versus State of Odisha. Para 22 of that decision. Next page.
Judicial review.
Yes. The portion in italics. Evaluating tenders and awarding contracts are essentially commercial functions Principles of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide as in public interest, courts will not, in exercise of power of judicial review, interfere even if a procedure aberration or so and so is made out. The power of judicial review will not be permitted to be invoked to protect private interests at the cost of public interest or to decide contractual disputes. Then Miller can always seek damages, etc. So Miller, this is for evaluating and awarding contracts. Now Miller, kindly come. My learned friend relied on 17, position of law with regard to interpretation of term. So the question as to whether a term of contract or essential or not is to be viewed from the perspective, these are essential conditions of Miller a tender. But it's absolutely clear, Miller, from Miller para 21, 22 and 23. Kindly see, Miller, bring page 22. Since the construction of road is an infrastructure project and keeping in view the intent of legislature that infrastructure project should not be state, the High Court would have been well advised, etc. Now, the satisfaction, whether a bidder satisfies the tender condition, is primarily upon the authority invited. Such authority is aware of expectations from tenderers while evaluating the consequences of non-performance. In the question, then Miller para 23. In view of the above judgments of this court, writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of, does not have to have the expertise to examine terms and conditions of present day, more reluctant in involving technical issues as a requirement of necessary expertise. This is Miller for evaluation. Now Miller, the and or case Miller which was relied on, Miller which is Miller the earlier Gujarat Urja. Miller, this was an arbitration case. Miller, my learned friend Miller relied on. Miller paragraph Miller page 755, 2008, 4 it's Supreme Court cases.
Yes.
Miller, kindly come to Miller paragraph 24 first. The main question before us is whether the application under section 11 of the 1996 is maintainable in view of statutory provisions contained in the Electricity Act for adjudication of disputes between licensee and generator. In our submission, the opinion submission of KK Venugopal has to be accepted. It may be noted that 86(1)(f) is a special provision for adjudication of disputes between licensee and generating companies. Such disputes can be adjudicated upon either by the State Commission or person or persons to whom it is referred for arbitration. In our opinion, the word and in section so and so between the words generating companies and to refer any dispute for arbitration means or. It is well settled that sometimes and can mean or and sometimes or can mean and. No dispute, but in the context of 86(1)(f), my lord, it says, my lord, either the commission can decide and my lord arbitration. So and there has to be or, otherwise my lord it has no meaning, my lord, for two forums. So my lord, in that context, my lord, it says section A is a special and hence will override general provision for arbitration. It is well settled. Special law overrides and section 11 has no. Because statutory authority, my lord, has to, my lord, decide. There are two forums available. You have a contract, you have, but the special act says it has to be, my lord. That's it in the context of, my lord, the interpretation of 86(1)(f). Then, my lord, comes, my lord, the next two decisions. You are the first two, my learned friend cited. My lord, 2001, 2 SEC 386 and my lord, 2022 SEC online 284, my lord. Both the decisions, service, disciplinary, my lord, proceedings, my lord, where, my lord, the law, my lord, is well settled, my lord, on this aspect. But, my lord, I've cited the blacklisting cases, my lord, which says, my lord, proportionality in all its force, my lord, has to be, my lord, examined by, my lord, because it's a serious civil consequence, which has also been noted, my lord, by, my lord, the courts. My lord, I don't want to say anything more on this. Now, my lord, my learned friend says that, my lord, loss could be of any type. The important thing is, my lord, the banning order, my lord, apart from anything else, in self proceeds on the basis of that it has to be financial loss. Your Lordship may make a note of it, my Lord, page 723, my Lord, where, my Lord, they said, my Lord, that loss,
second.
my Lord, they cannot yet, my Lord,
Ascertain.
yes. So, my Lord, it's clear, my Lord, that it is, my Lord, financial and nothing else. Now, my Lord, my learned friend, my Lord, cited, my Lord, on referred to, my Lord, various provisions, my Lord, I'll just take 2 minutes on this, of the tender conditions and, my Lord, the general purchase manual, my Lord, which is applicable to, my Lord, the tender, to say, my Lord, in several cases, my Lord, there is no reference to, my Lord, the 2-year, my Lord, and, my Lord, financial. Now, my Lord, kindly have a look first at, my Lord, page 493, 6. My Lord, 6.13.2. My Lord, banning debarment of business. My Lord, the heading at, my Lord, 492. Sorry, my Lord, 492.
492.
Lordship has, my Lord.
Yes.
My Lord, my learned friend referred to violation, transgression of integrity pact. And then, my Lord, my learned friend at page 493 relied on, my Lord, 6. My Lord, willful suppression. And my Lord made a specific point that integrity pact, my Lord, is what is important. My Lord, and there's no, my Lord, restriction here. My Lord, there is a restriction, but your Lordship will find that at 6.13.4. Period of banning, debarment. Period of banning should be decided based on gravity of the offense. And now, my Lord, kindly see. Quantum of loss. Lordship has that, my Lord. Not loss in the air, my Lord. It's financial. Quantum of loss suffered by, in case banning is proposed under 6.1.3.1, 2 and 3. And banning period should not be. In case banning is proposed under so and so, banning period should not exceed 2 years. Now, my Lord, kindly note one thing, that integrity pact, my Lord, which is referred to, my Lord, this is, my Lord, at page 132. My Lord, it's a pre-contract integrity pact that you will not bribe anyone. It's got nothing to do, my Lord, with the code of integrity, my Lord, which is there in the purchase policy. Kindly have a look, my Lord. Page 132. My Lord, pre-contract integrity pact. My Lord, 132. My Lord, which is volume 1, I think.
Yes.
My Lord, kindly see pre-contract in the bidders will have to upload along with their offer duly filled in signed stamp pre-contract on plain paper as per Annexure 6. Annexure 6 is at page 188. Kindly have a look. It's to prevent corruption. Pre-contract integrity. Has that, my Lord? Now kindly see, my Lord, after the recite, now therefore, to avoid all forms of corruption, Lordship has that, all forms of corruption that is fair, transparent, free from any dealings prior to, during and subsequent to the be entered into with a view to enabling the buyer to obtain the desired at a competitive price, so and so, enabling bidder to abstain from bribing or indulging in order to secure the contract. This is, my Lord, what, my Lord, this integrity pact is. And, my Lord, the show cause notice does not refer to, my Lord, all this. It refers to, my Lord, what I showed your Lordship, misinformation, my Lord, that, and, my Lord, maximum is 2 years, and both, my Lord, have to be considered. In fact, my Lord, at page 111, which my learned friend referred to, instruction to bidders, my Lord, clause D, false declarations will attract banning of business of bidder or its successor for a period up to 2 years in line with clause 36. And clause 36, my Lord, is at page 131, my Lord, which said, my Lord, will be decided based on gravity and the quantum of loss. So, my Lord, anything else? My Lord, I am grateful, my Lord. I think we. Naga.
রেকর্ড করে না অর্ডার একটা
Thank you for the power.
রেকর্ড করে
Mr. Mukherjee has
Order
today, my lord, given me, my lord, says more power to you.
Heard Mr. Mukherjee, learned senior advocate appearing for the petitioner, and Mr. Shaha, learned senior advocate appearing for the respondents. Full stop. Hearing is concluded. Judgment is reserved.
God bless. We should have more hearings like this.
Yes.
I was speaking to Mr. Shah, my lord. Whenever your lordship sits, my lord, we have, my lord, so many, my lord, important issues, my lord, which need to be decided, my lord, if you could come up and have them.
This is ideal, my lord,
Yes, I told
atmosphere
him, I said,
for a hearing such as this.
any hearing, my lord, read matters, whatever, if your lordship has that determination, my lord, we work. My lord, if your lord, and your lordship always work, and your lordship will continue to. So, my lord, we can, my lord, have, my lord, matters mentioned, because
Yes, yes,
seriously, my lord,
we
matters can be.
No, my lord, grateful, my lord, for the hearing.
এটা আজকে পাঠিয়ে দেবেন আজকেই ফাইলটা হ্যাঁ অর্ডারটা করে আজকেই দিয়ে দেবেন কারণ আমি স্যাটারডে সানডে বাড়ি নিয়ে যাবো